Social Media in the Law Office by Michelle Francisco for Computers in the Law Office, Spring Semester 2013. What is social media? Social media refers to the means of interaction among people in which they create, share, and exchange information, ideas, personal messages, and other content in virtual communities and networks. Major social networking sites used in the legal community include Facebook, Twitter, LinkedIn, Google+, and YouTube. There are many different ways that social networking websites can be used in the law office. They can be used to promote and market a firm or individual attorneys, attract potential clients, can be used to research and find job opportunities, provide information about clients, opposing parties, and business prospects, and discover evidence in a case. There are many advantages of using social media in the law office. First and foremost, it is inexpensive. Usually, the sites cost nothing other than the person's time and energy who's using it. It can reach large amounts of people extremely easily. Using social media can cause increased traffic to the firm's website if it is linked to your page. There can also be an increased awareness of the law firm itself and the services that it provides among target clients. Development of business relationships from networking through these sites can also be a plus. There is also several disadvantages of using social media. For example, certain content that's published can ascertain a negative image of the firm or its attorneys. There could be a leak of confidential information about your client or his or her case. Certain remarks that are said can damage an attorney, a client, or staff's reputation. Can also lead to damaging evidence in a case. Also, as seen more recently, there have been many lawsuits that have been filed over the content that has been published on social media websites. Social media is becoming an ever-increasing part of e-discovery because a major component of discoverable information is now stored electronically in various forms and in a wide range of virtual locations. ESI is data that is stored on an electronic medium, usually a computer or server, and which is accessed through some form of computer program. For example, it often includes emails, databases, Word documents, PowerPoint presentations, or spreadsheets. Social media pictures, posts, messages, and conversations can be included in e-discovery. More recently, the courts have held that if relevant, electronically stored information contained on a party's social networking site can be subject to discovery. Because many social media providers do not promise privacy to the user, data provided or posted by a party is not private, even if subject to various privacy settings, and can be considered discoverable. There are several ways an attorney can go about getting this information. For example, a lawyer wishing to obtain evidence contained on an otherwise private social media site may ethically seek such information by utilizing formal discovery mechanisms. Several courts have allowed formal discovery of information contained on social networking sites and find the practice is entirely ethical so long as the attorney assures that his or her discovery request is made in good faith or is reasonable cause and comports with the appropriate laws. When doing this, they would most often send a formal set of interrogatories or requests for production of documents to the opposing party. Attorneys can also engage in informal discovery of social media sites, but can face ethical problems when doing this. Lawyers should never use false identities and fabricated profiles to obtain access to and information contained on social media sites. Attorneys should also refrain from requesting friends or followers' status of represented person's profile. They should also not have a third party or their own employers doing this task for them. The discovery process of a party's social media pages are beginning to become issues heard by the court. In a 2011 Pennsylvania personal injury case, the court found that private portions of Facebook and MySpace accounts were fair game. The defendant argued that recent photographs and comments on the public portion of the plaintiff's page appeared to contradict claims of physical and emotional distress. They argued that it should have access to relevant information in areas designated as private. Based on the evidence, the court ordered the plaintiff to provide all passwords and usernames to the defendant and preserve all existing information. In another case, an attorney told his client to purge unflattering content or posts on his social media sites, and then the attorney was fined over $500,000. In a more recent case, filed by the EEOC on behalf of a class of female employees, the defendant filed a motion to compel the plaintiff's social media accounts and phone information. The defendant was able to prove that the request would provide discoverable information. The court found that this information was true, and they ordered that the plaintiff and the class members produce any and all cell phones used to send or receive text messages, information necessary to access social media websites, and information to access any email accounts, web blogs, or other internet communication devices. Some do's and don'ts for a paralegal using social media. Always remember that everything you do and post is open to the public eye. If you're using a business page, act in a positive manner. Do not post negative comments about the firm, its opponents, or clients, especially not about judges. On business pages, always respond to messages, posts, requests, and discussions in a timely fashion. And please remember to be genuine. Always remember to listen to what people are saying, especially because you never know who will become a future client. Keep in mind social media searches as evidence in a case, especially when dealing with personal injury and family law cases. When using social media sites for personal use, remember to not post negative things about your employer, coworkers, clients, even if you're not friends with them and have your profile set as private. Be mindful of the things that you post and know that they are public knowledge even with privacy settings. Future employees can look at your pages during the hiring process and can make or break a job opportunity for you. Always remember, think about what you're saying and the effects it can cause before you post anything. You never know what will come back to haunt you.